if you're represented by a lawyer, then this are some of the steps that your lawyer will be taking. But if you're a self-represented litigant, then this is something you would have to be mindful of if you want to bring an application for judicial review. So to file an application for judicial review, a person would have to first obtain permission. It's called the leave of the judge of the federal court. So you have to apply to the court for leave to commence a judicial review, an application for leave and judicial review before the federal court. With respect to immigration matters, you have 15 days to file, 15 days from the date that you receive the decision or when you were notified of the decision of the federal board or agency, for instance. And that's if the matter arises from within Canada. But if it's outside Canada, you have 60 days to file your application for leave before the federal court. If, for instance, because of some exigencies, you're not able to file within the 15 or 60 days time frame, then you would need to request for an extension of time, which will be made at the time when you're filing your application for leave. The application for leave has a form that it has to take. So let's say, for instance, as I mentioned earlier, if you're a self-represented litigant, there is a form that your application has to take. There's some details that you need to have included in your application for leave and judicial review. So for instance, the name of the parties. So if you had made an application to immigration IRCC, pardon me, if you've made an application to IRCC on, say, for instance, a study permit, party on the application for leave, and also the Minister of Immigration and Citizenship will also be a party. So anybody who's affected by the decision will be a party, and your name should be on the application for leave. The date of the decision must also be included in the application so that the court knows when because we're dealing with timelines here, and the court really needs to know when you received the decision, when the decision was made. We also would need the name of the tribunal, I said earlier. So let's say if it's IRCC, then the name of the minister has to be on the application. Your file number, so there was definitely usually a file number that's assigned on an application. For instance, if it's a refugee matter or an appeal, there will be a tribunal number that's been attached to, so that has to be included. You also need to include the specific request that you're seeking from the court, the place and language of the hearing. We have different registries across Canada, so wherever you want the hearing to take place, if leave is granted, should also be stated on your application. You should also include whether or not you had received the reasons of the decision, because you might actually receive notice, but you may not receive the reasons. So you should state that there so that the federal court will be able to provide, reach out to the tribunal to provide reasons. And very importantly, your signature, your contact details, or that of your lawyer has to be on the application. And this is very important in case of service, service of any document that needs to be effected on you during the application process. So still on procedure, so there is a filing fee that is attached to having your application for leave to be accepted at the federal court. Once that filing fee is paid, then your application will be reviewed by the registry and then accepted if it meets the requirements that have been set out earlier. So that fee is payable to the Receiver General of Canada, and you could pay that by cash or personal check or debit card. Again, if you're represented by a lawyer and you retain a lawyer on your application, then your lawyer will be the one to handle this for you. There is also a requirement for service and proof of service of your application on the respondent, and this has to be effected by personal service. So the respondent, that's the party on the other side, usually that's the government, the Department of Justice has to be served with a copy of your application because they're a party to the matter that you're filing. The proof of service has to be served on the respondent, and you have to provide that proof of service to the federal court within 10 days after your application is served. In addition to the procedures that have already been stated earlier, we also have the notice of appearance that has to be issued by the respondent. The respondent here is usually the Minister of Citizenship and Immigration, and the respondent has to file his notice of appearance within 10 days, otherwise they will not be entitled to receive any further document in the proceeding. So this is just to guide you and just let you know how the judicial review process works. So as I said earlier, if you're represented by a lawyer, then your lawyer would definitely know this process, and they will be able to handle the process while updating you about what is happening. But if you're a self-represented litigant, then this is something you have to be aware of. You as the applicant has to file your application record within 30 days of filing your application for leave. And if you have not received written reasons, then 30 days plus 10 days from the time that you received decision, allow you to receive the decision of the tribunal. So the application record includes, for instance, your supporting documents, all the information that you had filed with respect to your application, your claim, or your appeal, whatever the case might be. In addition, the respondent will also have an opportunity to reply. So they will have 30 days as well to file their own memorandum of arguments in respect of your application. And then the applicant as well will have an opportunity to reply to the respondent's arguments with proof of service. One thing that we need to be mindful of is that whatever documents that is served on either party in the application has to be, whatever document that is filed on either party in the application has to be served first, and proof of service is required for that document to be filed or taken as filed by the court. And a reply memorandum has to be served within 10 days of service. So in terms of the disposition of an application for leave, so what happens after all this process has occurred, and you filed the documents you're supposed to file, and the respondent has also filed, and the court has the latitude now to dispose of the leave application. And the court usually does this in writing without personal appearance of the parties. So if you had also applied for an extension of time, let's say, for instance, you couldn't meet the 15 days deadline or the 60 days deadline, then the court will also dispose of this request at that time. If the court dismisses a leave application, then the file will come to a close. There is no right of appeal in terms of a decision dismissing an application for leave. So there is no way for an applicant to appeal that decision. So if the application for leave is granted by the court will issue out an order, and it will spell out the date, the time and place and language of the judicial review application, as well as the time when the tribunal would have to send copies of the record. So as I said, and the record the record contains all the documents that have been submitted. Let's say, for instance, your study permit application or your sponsorship application. All those documents that have been submitted so far will be sent by the tribunal to the parties. Also, if leave is granted, a date will be set. It's going to be no sooner than 30 days from the date the leave is granted, and no later than 90 days from the date the leave is granted. So at a judicial review hearing, if you are represented by counsel, then your counsel will have an opportunity to provide oral submissions with respect to your application. And the respondent will also have an opportunity. The respondent in this case is the Minister of Citizenship and Immigration, because you're applying to the court to have the decision of a federal board or tribunal reviewed. So they have an opportunity to also represent themselves. And if you are not represented by a lawyer, for instance, then you would need to attend the oral hearing to represent yourself. And but if you are represented by a lawyer, as stated earlier, you don't have to be there. You can attend. You're not prevented from attending the hearing, but you do not have to attend if you do not want to. So we have a pictorial here that just describes how the application for leave and judicial review process works. We see here that where we see the applicant initiating the application, that's number 1. I don't know if you can see, it's a bit tiny, but I'm just going to try and explain the process. So we see the first step the applicant takes is to file their application for leave and judicial review. And then they file a proof of service. So they have to serve, as I said, you have to serve your document on the respondent, who is also a party in the application. And then the respondent will have an opportunity to file a notice of appearance. As I said earlier, if a respondent does not file a notice of appearance, then they would not have an opportunity to receive any document in the proceedings. And all this is also, then the registry, which is the federal court themselves, would request for the reasons, if you have not received reasons of the decision of the tribunal that maybe refused your application. They will send that to the court. And then you see there at number 5, the tribunal will then send the reasons forwarded to the court and provide that to the parties. And then the applicant will have an opportunity to file their application record. Your application record will include your written submissions and the documents that you have submitted in terms of your application. The respondents on number 7 there would have an opportunity to provide their own memorandum of arguments. And then you see there at number 8, the applicant will also be able to make a reply, that is within 10 days of the respondent filing their memorandum of argument. After which the pathway can either be for the application for leave to be dismissed. There you see a red light there, and that is where it ends. And then you go the other way, and then you continue to the judicial. If leave is granted, then you continue to the judicial review, the oral hearing stage, and then the court will determine the matter after an oral hearing or during the oral hearing. So that's just the pictorial of the process in terms of a judicial review application for leave and judicial review. So what remedies can an applicant who files an application for leave and judicial review obtain at the federal court? So the federal court, the power of the federal court in an application for judicial review is limited. So they are reviewing the errors and of the tribunal, not only the errors, they also look at the jurisdiction of powers and all that, but they just generally review that. However, the federal court can send the matter back to the tribunal for reconsideration. The federal court cannot grant you the specific remedy or relief that you're seeking at the tribunal. So let's say you applied for a study permit and it was refused, and you file an application for leave and judicial review. If leave is granted and the matter is gets to that stage and your leave is granted, the court can grant you a remedy if it is that there's been an error by the tribunal. The court can send the matter back to the tribunal to decide the matter again, usually before somebody different. Also, the court might issue a directive when they're sending the matter back for reconsideration. If there is a settlement agreement between you and the other parties, so there's an opportunity for you, the applicant, to enter into a settlement agreement. If the other side settles the matter before you go for a hearing, then there's a possibility that even the matter will be resolved before you get to the hearing stage. So in terms of the right of appeal, if an application for leave and judicial review is dismissed, you may not be able to appeal to the Federal Court of Appeal unless a judge or the federal court has certified that a serious question of general importance is involved. So if you had filed your application for leave and the court didn't find that there was an error and dismisses the application after the hearing, then the only way you can approach the federal court is if there's a serious question of general importance involved, in which case that kind of question will be a question that impacts a large number of people, the general populace. So for that to happen, so that is that about the process of the judicial review, application for leave and judicial review process. In terms of the impact of COVID-19 on judicial review applications, so there's been an order of the federal court extending the timelines to carry out an action required under the federal court Citizenship and Immigration and Refugee Protection Rules and the Federal Court Rules and the Federal Court Act and the Immigration and Refugee Protection Act to May 29, 2020. This is because of the COVID-19 right now. And after May 29, 2020, an applicant will have, or a party will have, an additional 14 days to take a step. Once, because this is suspended right now, the operations in terms of the timelines, the timelines with respect to these applications before the federal court has been suspended till May 29, 2020. However, you can still file, if you have something to file, if you're represented by a lawyer, your lawyer can still file something for you. However, the court has suspended the timelines. So, for instance, if you have an application for judicial review to file, you want to originate a new application, then you have the time to do so up until June 12, 2020. And if, for instance, well, this is only for judicial review applications that have begun after March or on March 16, 2020 or after. However, if your judicial review application had also begun before March 16, 2020, then that extension will also apply to you. So in conclusion, what we want you to take away from today's information session is who can approach the federal court. As I stated earlier, if you have been affected by a decision of a federal agency, particularly we focused on matters falling under citizenship, immigration, and refugee protection, then you can approach the federal court for judicial review. And I want you also to be mindful of the timelines. 15 days if your matter arose within Canada, and 60 if it arose outside of Canada. In terms of the applications that can come before the federal court, we mentioned earlier study permits, all kinds of applications, removal risk assessment applications, deferral requests, study permits, sponsorship applications, and almost any application made by an immigration, a federal agency or board in terms of a citizenship and immigration and refugee matter, and also a refugee matter, for instance, can also be reviewed by the federal court. So let's say, for instance, you receive your decision on a specific day. You have to be mindful that you have some timelines. If you're within Canada, you have some timelines. If you need to retain a lawyer, you have some timelines by which you have to reach out if you want to have that application or that decision reviewed. In terms of the procedural steps that needs to be taken at the federal court, you have to commence your application through an application for leave and judicial review. So the application for leave is basically you seeking the permission of a judge of the federal court to approach the court to actually review your application or your decision, the decision that was made. And in terms of the remedy that the federal court can issue, we've stated that the federal court will usually send the matter, but generally send the matter back for redetermination to the federal board to have that reviewed. And we have a procedural suspension in effect because of COVID-19. And we stated that the extension is till May 29th, 2020, and you would have an extra 14 days to carry out a step that you were supposed to carry out. So we have a question from Surat. She asked about getting a hearing date and whether it is possible for her lawyer to request a date from, I believe she wanted to say IRB, in terms of, I assume this might be a refugee matter. So I explained to her that yes, she can, her lawyer can actually write a letter or contact the IRB, whichever one is convenient for them for hearing date. However, that is entirely subject to the availability of the dates that the IRB has. Okay, so we have a question from someone here, Suleiman, and he says here that, can you please explain the reason why there is no further appeal to a higher court if there's a negative decision after leave is granted? So, so to address that question, that is entirely based on the federal court rules. So there is a right of appeal. However, as I said, I put the clause is that the federal court judge has to certify a question of general importance. So the federal court rules is clear on appeals that can go to the federal court. I don't know exactly why the rules states it's that way, but I mean, this is the federal court rules and we just have to go by what is in the rules. So while we're waiting for any other questions to come in, as I mentioned earlier, we are on social media and we would appreciate if you follow us on our social media platforms. And you can also contact us at info@TPM Attorneys if you have any questions in respect to this information session, if you have any specific legal issues that you would like us to address. And our website is also www.tpmattorneys.com. I also have another question from Adriana. Can you bring a matter from the FC that was refused to the Supreme Court? So there is a process, so you cannot go just from the FC to the Supreme Court because you would first have to approach the federal court. As I stated earlier, the rules are clear. The federal court judge would have to certify your question before you can approach the Federal Court of Appeal. if you have any specific legal issues that you would like us to address, or if you would like to contact us or reach out to us, you can use any of this. You can use information on this PowerPoint to reach out to us. And thank you all once again for attending this information session. And I hope you have a great day ahead.